The English Court of Appeal heard this case, which is an important case establishing the rules for the doctrine of frustration in contract law. Queen Victoria had died in 1901 after reigning more than 60 years. England mourned for a year, and then arrangements were made for the coronation of King Edward VII in 1902. The coronation was to include a coronation parade through the streets of London. Naturally, that meant that for those with money, any window or balcony overlooking the parade route became a hot property. Paul Krell had rooms overlooking Pall Mall where the parade would pass, and he was going to be overseas at the time of the parade. He let out his rooms for £75 for the 2 nights. To put it in perspective, that's worth more than 20,000 Australian dollars today. They made a contract and Mr. Henry paid a deposit. Then suddenly the king became terribly ill and needed abdominal surgery. The coronation and the parade were cancelled and rescheduled. Henry, of course, didn't pay the rest of the money. Krell sued for the rest of the money on the basis that Henry had agreed to rent the rooms, and the contract didn't specifically say anything about the coronation parade. The court found that the contract was not in fact just to hire the rooms, but instead it was a contract to hire rooms for the specific purpose of viewing the coronation parade. Once the parade was not happening, the contract was frustrated. That is, neither party was in default, neither had done anything wrong, but the nature of the contract had completely changed, and each party should be released from their obligations. Lord Justice Vaughan Williams said, "In each case one must ask oneself, first, having regard to all the circumstances, what was the foundation of the contract? Secondly, was the performance of the contract prevented? Thirdly, was the event which prevented the performance of the contract of such a character that it cannot reasonably be said to have been in the contemplation of the parties at the date of the contract? If all these questions are answered in the affirmative, as I think they should be in this case, I think both parties are discharged from further performance of the contract." That statement remains an accurate statement of the rules of frustration to this very day.